Heichka, for those kind words. Say good evening. I want to start by recognizing our Coast relatives on whose territory we're gathered this evening. Thank Leah and Renee for the welcome and the kind introduction. Want to spend this evening trying to condense what would likely be one semester of study into 1 hour. So we'll see how good we do. I'm going to have to go fairly quickly, but I believe that the PowerPoint will be put up on the website, so hopefully those of you that are trying to take notes won't feel that you're having to write a little bit too fast. So this evening, I want to spend some time talking about Indigenous land rights, and talking about it from the perspective of the domestic law and the international law around this important area that has been developing for the past few years now. The domestic law here in Canada has a constitutional foundation, and we know that Section 35 of the Constitution of Canada recognizes the existing Aboriginal and treaty rights of the Aboriginal peoples, and those rights are recognized and affirmed. However, there is no legislative implementation framework for that Section 35. And so we have to rely on the common law in order to understand what Section 35 means and how Section 35 will be implemented. When we think of the common law in terms of Aboriginal rights, common law freedoms are not like human rights type freedoms or claims. The common law freedoms are built up as a general principle established by individual cases. And so in this area we go back to the case of Calder, brought by the Nisga'a people many years ago in the 1970s. And that was the first case where Indigenous or First Nations rights to land was discussed by the Supreme Court of Canada, and in modern times. And in that case, the governments argued that, well, all of the land rights of the First Nations in British Columbia have been extinguished. They no longer existed. This case went up to the Supreme Court of Canada, and the judges split. The Supreme Court of Canada split. 3 judges agreed with the Crown that, in fact, these land rights had been extinguished. 3 judges ruled that, in fact, those land rights had not been extinguished. And the 7th judge decided the case on a technicality and ruled that because the Nisga'a hadn't gotten permission to sue the government, that they were not able to get any kind of a declaration of title. But that started the process. So in the common law then, you have this precedent being established that, in fact, it was a question. Did the rights exist or did they not exist? The next case to go forward then was the Delgamuukw case. In Delgamuukw, the Gitxsan and Wet'suwet'en brought this case before the Supreme Court of Canada. And this time the Supreme Court of Canada ruled unanimously that, in fact, the land rights of Indigenous peoples in British Columbia had not been extinguished. So that was the next progressive step. And they outlined a number of factors that need to be taken into consideration. But again, the Gitxsan and Wet'suwet'en didn't get a declaration of title because the Supreme Court said, well, the trial judge had so misinterpreted and misapplied the facts of the case that it made it impossible for them to issue a declaration of title in that case. So, they sent the case back to be retried. And because the Gitxsan and the Wet'suwet'en haven't been able to have the financial resources to start over again, that case has not been retried and continues to wait. But it moved the law forward. So now you see this gradual kind of way that the common law evolves. You move from Calder to Delgamuukw. So now you've gotten so far as to say, well, the rights exist. And they've given some parameters around the rights. The next case to move forward was the Williams case. The Chilcotin people brought a land claim case. And this case has now been argued at the Supreme Court of Canada. And in this case, then, the Chilcotin people, again, are arguing and have argued that their land rights should be recognized by the Government of Canada and the Government of British Columbia. And again, the governments are arguing against the recognition of those land rights. When we look at the BC Court of Appeal, which is the decision that went up to the Supreme Court of Canada, here's what the judges in the BC Court of Appeal had to say. Aboriginal nations were not recognized as nation states by the European nations colonizing North America. European explorers considered that by virtue of the principle of discovery, or the doctrine of discovery, they were at liberty to claim territory in North America on behalf of their sovereigns. And then the Supreme Court said, or the Court of Appeal said this: while it is difficult to rationalize this view from a modern perspective, the history is clear. There was from the outset never any doubt that sovereignty and legislative power, indeed the underlying title to such lands, vested in the Crown. So that was the beginning point for the Court of Appeal. They then went on and said that exploiting the land, the rivers, the seaways for hunting, fishing, and other resources may translate into Aboriginal title to the land if the activity was sufficiently regular and exclusive to comport with title at common law. So now you see them beginning and carrying on with some of the comments that were made by the Supreme Court of Canada in terms of, well, what does First Nations have to prove in order to establish their title to the land? And they then go on and say it supports the view that title must be claimed on a site-specific basis, and that a certain regularity and intensity of presence is needed before it will count as occupancy. They go on. The problem for the Chilcotin is that mere occupation of land does not necessarily establish Aboriginal title. If an Aboriginal group has used lands only for certain limited activities and not intensively, the group might have an Aboriginal right to carry on those activities, but it does not have title. So now the court pushes it even further. They say not only do you have to establish that you used the land, but you have to establish that you used it exclusively and that you used it intensively. They go on. Case law does not support the idea that title can be proven based on a limited presence in a broad territory. So again, they constrict how and where First Nations or Aboriginal peoples can establish title. Rather, Aboriginal title must be proven on a site-specific basis. A title site might be defined by a particular occupation of the land, for example, village sites, enclosed or cultivated fields, or on the basis of definite tracts of land where that were the subject of intensive use, specific hunting, fishing, gathering, and spiritual sites. They went so far as to say, for example, the rock that you stood on when you went to fish. So they began to narrow this concept of title down to these very specific sites. In all cases, however, Aboriginal title can only be proven over a definite tract of land, the boundaries of which are reasonably capable of definition. So again, you see what the courts are doing. They're narrowing down under the common law where First Nations are able to establish title to land. They go on. This view of Aboriginal title and Aboriginal rights is fully consistent with the case law. So again, common law. It is also consistent with the broader goals of reconciliation. So now the court moves from this sort of legal analysis of this, and they move into sort of policy considerations, reconciliation. There is a need to search out a practical compromise that can protect Aboriginal traditions, not rights, but traditions, without unnecessarily interfering with Crown sovereignty and with the well-being of all Canadians. An overly broad recognition of Aboriginal title is not conducive to these goals. So you see, the Court of Appeal begins to narrow down legally the rights of First Nations, Indigenous peoples under the law, and they also begin to narrow it down in policy under this concept of reconciliation. So they begin to take a very restricted view of what title is. That case has been appealed to the Supreme Court of Canada. It has been argued. And in that case, the Hul'qumi'num Treaty Group and Amnesty International intervened at the Supreme Court of Canada level. I argued the case for Hul'qumi'num, and we argued that the Supreme Court should begin to incorporate international law into domestic Aboriginal law. The Hul'qumi'num Treaty Group submitted that there is an implementation gap of domestic and international law respecting Aboriginal rights, as evidenced in the admissibility report of the Inter-American Commission on Human Rights in the Hul'qumi'num case, being satisfied that there were no effective domestic remedies to address the resolution of the Aboriginal land issues that the Hul'qumi'num Treaty Group had raised. And we'll get into that in a little bit. We also submitted that the current land claim litigation and treaty negotiation processes are too lengthy, too costly, too complicated, too inflexible, and uncertain. And if the Court of Appeal's decision or opinion is upheld, it will become even more so. So Hul'qumi'num Treaty Group lastly submitted that the only acceptable practical compromise is to construct a new paradigm based on the promotion and protection of human rights by integrating the framework of international law principles dealing with Indigenous human rights into the fabric of the domestic Aboriginal rights law to provide a way forward to achieving reconciliation through more effective processes. So when we look at this notion of international law then in relation to human rights, that draws from a number of sources. The Charter of the United Nations talks about equal rights. It talks about self-determination, about the promotion of respect. The Universal Declaration of Human Rights talks about the right of everyone to own property alone or in association with others. The International Covenant on Civil and Political Rights, again, talks about self-determination. Article 27 talks about states or countries where there are ethnic or religious or linguistic minorities, that those persons should have the right to enjoy their own culture, their own religions, their own languages. The International Labor Organization has passed an article, 169, Convention 169, which addresses Aboriginal or Indigenous people's rights. And in that, Article 14 talks about the right of ownership and possession over lands that they traditionally occupied should be recognized. Particular attention should be paid to situations of nomadic peoples. And it's interesting that in the BC Court of Appeals decision in Chilcotin, this was one of the things that they highlighted. They highlighted the fact that the Chilcotin people were nomadic. And because they were nomadic, it somehow undermined their right to hold ownership of land. Here we see, the international principles here are different. That governments should take steps take steps as necessary to identify the lands traditionally occupied to guarantee effective protection of their rights of ownership and possession, and that adequate procedures shall be established within the national legal systems. Here in the Americas, under the Organization of American States, of which Canada is a member, The American Convention on Human Rights, which Canada has not signed on to, has not signed this international treaty. Under that treaty, it talks about the right to equality. It talks about the right to property. So we have this framework of international law that has been established and continues to grow. And how is that interpreted in terms of the rights of Indigenous peoples? How do these international instruments relate to Indigenous peoples?